everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney, and today we're talking about punitive damages under New York law. Punitive damages are available when the defendant's conduct is so egregious and malicious and spiteful that it hurts the public. It's geared toward the public at large, and the law says you cannot allow this type of conduct to happen. And what you have to do is punish the defendants by issuing an amount of money, making them pay that money as a judgment to deter this type of conduct from happening in the future. And there was a CLE recently called the Annual Damages Update from the New York State Academy of Trial Lawyers. And there were two cases about punitive damages and what they mean in New York. So I wanted to talk about that because I saw there were a few comments on our channel where you guys asked about punitive damages. They're also known as exemplary damages. And you know, they do vary from state to state. So each state will have their own rules and laws about punitives. In New York, I believe it's harder to get punitive damages compared to other jurisdictions. So the first case was out of the 4th Department, which is upstate New York, and it involved medical malpractice. It was a case where a plaintiff sued in a medical malpractice lawsuit because she sustained severe injuries. The defendant failed to properly treat an abdominal skin condition. It doesn't give details. I mean, we could read the actual case, but this particular CLE didn't give specific details as to what the defendant did, but it was a failure to properly treat this stomach skin condition, and it led to a very long hospitalization and the need for emergency medicine. And what the 4th Department Appellate Court said was that the standard for imposing punitive damages is very strict. And punitive damages will only be awarded in exceptional cases, and that the conduct that would justify a punitive damages award must manifest spite or malice. So spite is, I guess, defined as intentionally wanting to hurt someone, right? Being spiteful. And malice is obviously like evil, right? Being malicious. So that's one of the conditions, right? The other way is if the defendant has a fraudulent or evil motive or such a conscious and deliberate disregard of the interests of others that the conduct may be called willful or wanton. So I think that's important because, you know, they give you 3 different sections, 3 different categories, but they're all kind of pointing to the same thing. They're not saying that like reckless conduct could even qualify. They're saying that it has to be spiteful, that you're like intending to hurt someone, right? Or that it could be fraudulent or evil, the motive behind it, but it has to be like a conscious and deliberate. So you have to knowingly and deliberately plan and have this plot to disregard the interests of others, that your conduct is going to really hurt others, and that the conduct could be called willful, that you want to do this, and wanton, that it's just so dangerous. So, I mean, I'm not sure exactly if, I guess the question I would have is, what about recklessness, right? What about if somebody is just so reckless that they know that the conduct could potentially injure the public at large, but they don't necessarily want to injure people, right? They're not like a serial killer who I'm going to go out there and injure people. I'm just doing really reckless, really dangerous things that are likely to injure people. Would that qualify? And, you know, it's a little bit unclear. I guess from this one decision, we'd have to look at some other decisions. But this court said the standard for an award of punitive damages is that a defendant manifest evil or malicious conduct beyond any breach of professional duty. So I guess like, even if he breached, right, this doctor breached his professional medical duty to be a qualified, competent doctor, even if he was like, you know, sometimes people say the lowest common denominator, right? Like, so let's say the lowest common denominator is what a doctor should do, right? A reasonable doctor should do. Even if he just completely breached that and was way down here, just really horrible conduct, it doesn't matter, right? Because it's not anything to do with a professional duty, but it has to be this like manifesting evil or malicious conduct. So that's pretty hard. That's pretty hard to prove. That's going to be only in some exceptional circumstances. And so the Fourth Department held that defendant met its burden on summary judgment, and that the plaintiff failed to raise a question of fact for a jury to even decide, and so they just dismissed the punitive damages claim. You see, because the standard is so strong, it doesn't even get to a jury, because to get to a jury, you have to have an issue that the jury is able to decide, right? A question of fact. But because the standard is so strict that the court said, well, it's not even close, right? There's no way a jury could even decide this, so it's just dismissed as a matter of law, and that's what summary judgment is. And so the other case was a case that involved insurance bad faith. And there, a plaintiff was injured, and it was an automobile insurance policy issued by the defendant. She was struck by a vehicle while she was in the crosswalk, and the plaintiff made a claim to the defendant under the underinsured motorist provisions of her policy. And so the insurance carrier for the defendant, the person who struck this lady in the crosswalk, tendered their full policy of $25,000. So they paid the full $25,000. That's all they had. And then plaintiff notified the defendant of the tender of the insurance coverage, and defendant consented to the settlement. And then she wanted to go after the underinsurance. So the way that works is, once you take, let's say a car hits you and the car only has $25,000, you take the full $25,000, but maybe you are more careful, right? Because that person is underinsured, meaning they're not insured for enough, right? They're only insured for $25,000. That's the state minimum. What if I am insured for $250,000, right? So what I could do is take that 25, get the consent of that company for the 25, and now I can go after my own insurance and I can get the difference, right? I can get 225 more because I already got the 25 from the defendant who was at fault. They had very little insurance. They were underinsured. Now I get the rest from my own policy. And I believe that's what the plaintiff here tried to do. And she wasn't having any luck. This company that she had was just not paying. They were engaging in, I guess, what you could call potentially bad faith. So she wanted to sue them for punitive damages too. And she started a lawsuit against them to recover the remaining policy limit in the amount of $225,000. It was exactly the same scenario. And she wanted punitive damages for that. And she said it's based on defendants' bad faith in breaching the insurance contract. And so the appellate division here was actually the second department. What they held was they also dismissed the case for punitive damages. They said that a breach of contract action, the elements of punitive damages, you have to prove 4 different things. Because here, she's suing her own insurance company and she has a contract, right? The policy, the insurance policy is a contract. She's paying premiums. She signed. They're giving her the benefit of insurance. And so suing them is like a breach of contract. And so there are 4 things she has to prove. Number 1, that the insurance company's conduct must be actionable as an independent tort. So it has to be a separate tort. The tortious conduct must be of the egregious nature set forth in the case of Walker versus Sheldon. So I guess we'd have to look at that case to see the standards. The egregious conduct must be directed to the plaintiff, and it must be part of a pattern directed to the public in general. So the court said where a lawsuit has its genesis in the contractual relationship between the parties, the threshold task for a court considering a defendant's motion to dismiss punitive damages is to identify an independent tort. So basically a tort that's independent of the contract. Was there such a tort? And here the second department said that the plaintiff in her complaint failed to allege an independent tort for bad faith refusal to comply with an insurance company. So I guess it's leaving the door open, right? If the plaintiff had alleged like a cause of action for bad faith refusal to comply with the insurance, perhaps then they would have allowed punitive damages. They also said that the prima facie case of bad faith refusal to settle, in order to establish that, what you would have to do is you would have to show as an insured, right, because you're a policyholder, you would have to establish that the insurance company's conduct was a gross disregard of the policyholder's interests, meaning that it was a deliberate or reckless failure to place on an equal footing the interests of its policyholder with its own financial interests when considering a settlement offer. But it said here it wasn't really a question, right? And I read the decision too, because this is just a CLE summary, but I read the actual decision. And what the decision said was you can't really do it because there's no exposure to the policyholder, right? If the insurance company was failing to protect a policyholder, like for example, if you're being sued, right? Now, if the insurance company doesn't pay your policy, like for example, you have 100,000 policy and the insurance company says, I don't care, I'm just going to offer 10,000. Well, now the plaintiff could hit you for $1 million, and who's going to pay the difference, right? Anything over 100, that other 900,000, you're liable for that, right? As a policyholder, as an insured. And so they're endangering you, right? That could be bad faith. But here, it's like your own policy. You're just trying to say that the person who hit you in the crosswalk had very little insurance. You're going underinsured against your own policy. You feel like you're entitled to the 225, and they just feel like, no, you're not. Maybe you're entitled to like 50 grand. Maybe your injuries just don't qualify. And so the court is saying that it would not rise to punitive damages. And so finally, it says the court held plaintiff failed to allege any facts from which an inference can be drawn that the defendant's conduct was of an egregious nature. So yeah, those two decisions, I guess neither of them are really that helpful, but there are certain situations where punitive damages can be obtained in New York. And there have been punitive damages verdicts. Recently, there was a verdict out in California, I believe for about 60 million for punitive damages, where a lawyer represented a city of Modesto against a big chemical company. And it was held that the chemical company, I believe it was Dow Chemical, knowingly released like chemicals and cost the city a lot of money and hurt people. And so there was the actual verdict was less. It was like 3 or 4 million, but then because of the punitive component, it was like 56 or 57 million. So the total was 60 million. So punitives are possible. It's harder in New York than in other parts of the country. Okay, I hope this has been helpful. Let us know what questions you have about punitive damages or about other topics. Okay, talk to you soon. Have a great day, everyone. Bye-bye.